and I would propose that we start this exceptional Global Digital Encounter dedicated to a major European success, the Unified Patent Court. The Unified Patent Court is now at age 2, was at age 2 on the 1st of June. And whereas prior to the conclusion of the treaty that created the court, and at start of the court, there were so many questions on whether it would be a success or not. It results from experience, from 2 years experience, that a considerable achievement has been made thanks to the existence of the Unified Court, of the Unified Patent Court. Clearly enough, there are still many questions that are under discussion, rules of procedure, transparency, cooperation, and also relationship with the EPO proceedings. There are also issues connected, of course, to having more EU member states in the system, but clearly enough, the results, the outcome of the courts are remarkable and acknowledged even by those who criticized the creation of such a court. This court, which is relatively atypical in the European construction, may pave the way to other forms of European constructions and show that in these complex times, Europe is offering a good example in the field of intellectual property, in this case in the field of patents, of cooperation, of developments that are promising and respond to market needs and to growth needs. This is why for this 38th Global Digital Encounter, we invited, well, the most qualified person to be our keynote speaker today, President Klaus Grabinski, who chairs the new court, the Unified Patent Court, and who will share with you in a very informal way this afternoon, for those who are in Europe, we will share with you his experience and many of the developments that were possible thanks to his energy. Our second speaker comes from a country who is not yet party to the to the Unified Court, and also has organized in the past some activities connected to the Unified Patent Court in his country. His wealth of experience and knowledge on the development of this project will also challenge all participants and also other speakers on this very issue. Now, at the Global Digital Encounters, who else than Professor Manuel Desantes could be the moderator of this very session? Professor Desantes was Vice President of the European Patent Office, created one of the most authoritative law program on intellectual property at the University of Alicante, has immense international experience in intellectual property matters, but also in public and private international law, which is one of the key issues while creating a new court. So this is why we are happy and honored that as co-director of this Global Digital Encounter, Manuel Desantes be our moderator today. Dear participants, I would also wish to thank all of you, for those who attend live and for those who will watch the session later on, for being loyal and close to the Global Digital Encounters. This is the 38th edition of it. This edition marks the 5th year of the Global Digital Encounters project. Well, actually, we are entering with this GDE into the 6th year. So this is a long-standing project for which FIDE, the Spanish Foundation, and the Transatlantic IP Academy are so proud of. We would wish also to thank all our supporters. This is a pro bono activity, and we are so happy that so many people all around the planet support this very project. We are also so happy to see among the participants today, academics and professionals from all continents. We even sometimes woke up or we go to bed very late, woke up very early, or we go to bed very late to be with us at this exceptional event. Well, thanks to all of you for being close to the Global Digital Encounters project. And I think I should now give the floor to our esteemed moderator, Professor Desantes, and of course to President Grabinski and to Tomasz Gawlicek. Manuel, the floor is yours, and we stay together for this small hour that we shall spend on this super beautiful development in the European Union.
Thanks very much there, Laurent. You know, the Global Digital Encounter is a typical product of the COVID. 5 years have passed and we are still there, Laurent. The UPC is much younger. It's only 2 years old, but it's much longer in the experience. I still remember that I understood that something like that could be brought into the imagination of lawyers, and this was in 1962. Was more than 60 years later on. We are here, and we are here after 2 years experience. As Laurent said, there were quite an amount of people being, and scholars being very loyally, quite, let's say, opposed to the fact that the system moved out of the European Union, and I was one of them. After 2 years, I have to say that the system works, and for an academic, this is not easy. Good morning, Klaus, and good morning and good afternoon, Thomas. It is not easy, but it's also a way to express loyalty. The system works. This is the first time we have an actual international and national court at the same time in any field of law. And I always appreciate now the work which is done in the whole framework of thousands of people dealing with the UPC, not only from the perspective of the patents or even intellectual property, but from a larger understanding, because I'm convinced that with the experience of the UPC, one day or another, the whole system could be exported to many other fields of law, like consumers, like insurance, like labor law, and so on and so forth, bringing another way of understanding how to solve conflicts. And we do need this. So today we are going to evaluate a certain number of questions, sometimes minor questions, sometimes big questions, taking into account the experience. And I would like, Klaus, if you don't mind, start with quite a hot issue, let's say, entering into the swimming pool right away, which is the issue of language. The issue of language, we are not going to deal with yes, no, and no, what is the political issues behind, but I would like to know, Klaus, what is the experience behind these 2 years? Is language an issue? Do you appreciate that, in fact, in practice, the language system of the UPC is working, it could be improved? You have the floor, Klaus, and thanks for coming, you both.
Okay, thank you very much again for your introduction, for inviting me to this wonderful conference. Also, thanks a lot to Laurent Mondrieux for this. And well, language indeed is a very hot topic. As you know, as everyone knows, in Europe we have the principle of equality of languages. So essentially, all languages matter the same, are on the same level. On the other hand, we have the patent system, the European patent system, and in the European patent system, there are 3 languages which can be chosen for the language of the patent, which are English, French, and German. And in this situation, the Unified Patent Court tried to accommodate these two systems. And this was done in a way that local divisions, they are hosted by one of the UPC member states. They usually have the national language of that hosting member state as one language of proceedings. However, all UPC member states that host a local division decided to alternatively offer English as one of the EPO languages as an alternative language of proceedings. And so every time action is brought to the UPC, the claimant can choose either the local language or English. We have a regional division where English is the only language, even though they have 4 national languages, the 3 Baltic languages and the Swedish language, because it's a regional division of the Baltic states and Sweden. And we have the central division, and the central division, the principle is that it's the language of the patent that matters. So if the language of the patent is English, then the language of proceedings in the central division is also English, and the same with French and German. Maybe interesting to tell you the languages in the EPO. It is 75% of all patents. There, the applicants have chosen for English as the language of proceedings. 20% roughly German and 5% French. And now you see the same, more or less, at least along the lines in the UPC, because very often parties now choose for English as the language of proceedings. At the beginning, there was a certain bias in favor of German, because many cases are brought in the local divisions that are located in Germany. So there was German had quite some influence, but now slowly it is moving in favor of English. And
even in Germany, Klaus?
Sorry?
Even when the case comes in Germany?
Yes, it is moving now more from German to English. And to give you the numbers, currently it is about 55% of all proceedings that are run in English, about 37% in German, 4% French, 2 Italian, 1 Danish, 1 Dutch. So there you see the reality chosen by the parties. And maybe one more thing, I mentioned that it is the claimant who has the right to choose the language of proceeding, either the local language or English. However, when the defendant feels that it is unfair to choose the local language, then the defendant may go to the president of the court of first instance and ask for reasons of fairness whether the language should be changed into the language of the patent, which most of the time is English, as mentioned. So, and that happened a few times in the past, and there is already the Court of Appeal issued a decision which was in favor of, in case of doubts, in favor of taking the language of the patent. So if there is no close ties to the respective place where the claim has been brought, for example, if 2 US companies having a litigation in a local division that is located in Germany, for example, in the Munich division, then the claimant may have good chances to ask for a change of the language if, in the first place, German has been chosen as the language of proceedings.
I see. Thank you, Klaus. Thomas, do you want to add something?
Well, I would like to start. Thank you, Manuel. I would like to start with thanking for your kind invitation to today's panel and invitation to the Digital Global Encounters family. And it's really an honor for me to share my observations, especially in such an esteemed company with the Judge Grabinski, who knows everything from the very inside about the court, and with 2 esteemed professors and patent law.
I agree.
But my observation concerning languages are from the outside of the system, as I'm from Poland, and language issue is one of the most sensitive and practical issues before the Unified Patent Court, and it was during the establishing the system. And so far, as Judge Grabinski said, English has clearly become the dominant language of the UPC proceedings. But what is important for me is that the Court of Appeal has been clear that the language rules must become not a barrier to justice. And we have these two judgments issued by the Court of Appeal in Curio Bioscenic and on a patent that are defining some crucial conditions when it comes to changing the language of the proceedings according to the Article 49, paragraph 5. So when thinking about the language issue, for me, the key challenges before the UPC is balancing linguistic fairness with procedural speed and clarity. And what is also very important, especially for the countries from the outside of the system, is ensuring small and media enterprises and non-native speakers that are not disadvantaged by the system and by the proceedings. And of course, we can make some parallels to other proceedings that are conducted within the EU, because of course, when you are conducting proceedings before the CJEU, you might also be using other than native language. And of course, when we are looking at the EU IPO, that's the same case. So I would not say that it should be any barrier for the entrepreneurs from the other jurisdictions, as English is Latina franca today. And the last thing for me is avoiding delays or appeals due to the language misunderstandings. So if we manage to deal with the language issue at the very beginning of the proceedings, it might be helpful to handle the proceedings within the 1 year, which is the crucial deadline for litigation before the UPC.
Thanks, Thomas. Yeah, do you want to add something, Klaus?
Maybe very briefly, there's one more aspect. Well, the Unified Patent Court is a patent court, which means that the court has to deal with technical cases. And their understanding is maybe even more important than in, let's say, cases that don't have this technical aspect. And it's even more difficult to understand certain facts and circumstances. And in that regard, I think it's also very important that the parties and the representatives and everyone involved, judges, use a language they understand, and that makes it possible to communicate about very specific issues. And there, I think English is a language that is used in cross borders, and so the tendency is clearly in the direction of English, as long as there are not really some good reasons to say why another language should prevail.
Yeah, thank you.
And one more question. Please. Let me add, because I also saw the previous digital encounter in which Judge Riam Kalden was discussing also the language issue before the UPC after the 8 months from the very beginning of the launch of the system. And she said something very important, that the English language is now is not a native language for any of the countries which are within the system. So it is also fair to use this language, and it confirms that it's a right direction, that we have now more than 50% of cases pending in English.
Yeah. Mm-hmm. We have a question dealing with language, which is quite a political one, but I have to bring it to you, and I have an answer if you want instead of you. It's one of the assistants said, in which extent a language is still an issue for Spain to join the UPC countries. Yeah. Being a Spaniard, I would like to advance that it is not an issue, because today, unfortunately, the issue of Spain joining the UPC is not an issue. I mean, the political environment in my country impedes any decent, let's say, discussion today on these issues.
But Emmanuel, I can say something about it. As far as I remember, there was a point in the negotiations a long time ago where Spain said, okay, if it's English only, we are fine with it. We are getting closer to it. We crossed the 50%. So I hand it back to you.
That's true.
Think again about it.
You are right. This happens already 15 years ago. Yeah. No, and also, and I just leave just in order to give an answer, if I may. More and more, what happens in Spain also is that we start understanding that the unitary patent is a political issue, while the UPC is not a political issue. And there are many patents, European patents, that are validated in Spain, and joining the UPC, even if not joining the unitary patent system, let's say, which is feasible, which could be a starting point, let's say, could be a case for discussion the day it would be possible to discuss these kind of things in Spain without shouting each other, let's say. So I think this is enough for languages. We will devote perhaps the next year or the next but one another specific global dictionary encounter to languages in order to see how things experience. I could like now to move to another issue which is extremely relevant for a young and modern court like the UPC, and it's transparency. Transparency and public access to case files. And there, I also believe that the UPC is giving quite a splendid example to other courts all over the world. How do you feel this, Tomasz?
I totally agree with you, Manuel. So transparency is one of the core principles for modern judicial system, and for the Unified Patent Court has made this a priority from the day one, in my opinion. But what is the core? We should look at the rules of procedure and to rules 262 and 262A, which was added to the rules of procedure, and it is stated that UPC maintains an official register that shows the progress of the case. So this is a significant step forward compared to many national systems where patent litigation often happens behind closed doors. So we can just see what is in behind. But the system, in my opinion, is still finding its balance. And the question is, how do we strike the right balance between openness and confidentiality? And the UPC has the tools to do it. So the parties can request reductions or restriction access, but they have to justify it. And the court is developing a practice of carefully weighing the public interest in transparency against the legitimate interest in protecting confidentiality information. And we were all waiting for the very interesting decision of the Court of Appeal issued on the 10th April in Ocado case, which concerned public access to the register. And the key issue was to weigh the interest, yes, and include the protection of confidential information and personal data. But personally, for me, another key distinction the court made in this was distinction between ongoing and concluded proceedings. And for the concluded proceedings, including those settled without a final decision, the court said that the access should be generally be granted. So this is crucial. Unless, of course, there are confidentiality issues or personal data to protect. But on the other side, for the ongoing proceedings, a member of the public needs to show a direct interest. For instance, being a competitor instead interested in patent validity or having a product similar to the one involved of the case. So in conclusion, this ruling strikes a balance. It supports, for me, a transparency, which is very important, and I appreciate the UPC stance on this, especially after cases are over, but still protects fairness and confidentiality while the case is ongoing, which is also very important.
Mm-hmm. Thank you, Tomasz. How do you perceive this, Klaus?
Yeah, I think Tomasz very well explained the system, so I can't add anything on Ocado and jurisdiction of the COA in that respect. Maybe one point which is important to understand is that access to the register, including the files, has two different perspectives. The one which is dealt with in Rule 262 is between access of the public. So people that are not directly concerned by the litigation. So neither claimant nor defendant nor no intervener into the system. So that is one aspect. 262A is addressing a different situation. It's between the parties, because there can also confidentiality interest be involved. And that, of course, also interesting because it particularly comes up in the friend cases, when the patent owner is required to lay open to disclose so-called comparable licenses, which are most of the time are protected. As to the confidentiality of the content of these comparables. And very often there's a fight between the parties to what extent this can be disclosed to the other party. And the standard in Europe is that confidentiality interests should be observed, of course, but that it then will be disclosed only to a few people on the other side, meaning a so-called confidentiality club. So what we regularly are the representative of this party and at least one member of the respective company, but they all have to commit themselves not to disclose the information they get from the access to their own parties, to other people. And we are currently working, and we have cases where are the limits. Also discussion, okay, who should be a member of the confidentiality club. We had one case, for example, when it was, okay, should it also be US lawyers that were involved on the one party side. So they're now coming up more specific questions, and it causes a lot of work for the court to draw the lines there. And sometimes, to be open, I'm also a bit worried because it costs a lot of time, and I still tend to think that is a side issue that is not really the most important issue, because the most important issue is to decide the case at the end of the day. So I'm a bit worried that this takes a bit too much time away from the judges that, as already mentioned, are supposed to decide in a case, in a regular, normal, easy case within 1 year. But of course, the more complex these issues become, the more time it will take. And the more the longer it will also take. Yeah.
Thank you. You know, my perception as an academic from outside is that the UPC has become an extraordinary laboratory when dealing with these issues, which are the forefront of how a court should behave today in modern times, let's say. And this is even more exciting when you feel that there are so many cultures behind, and the issues regarding transparency and public access to case files very differently perceived in the different countries. Yeah, there is another question which is related to this one. Let's say whether we can take it. I will read it for you. It says, could the UPC consider to implement more robust search system in the UPC register to identify relevant cases? For example, by implementing a full text keyword search in UPC orders on decisions. Could you very briefly summarize?
That's on the bucket list of the court. Yes, we on a midterm we will try to make this possible. But there is a couple of other things we also have to deal with, and we have to prioritize this to some extent. But midterm, yes, it will come.
So, you know, Alexander is in the pipeline. Yeah. Let me move, if you allow me, to another issue which is very dear to me. For quite an amount of years, as an academic, I said, I follow very, very closely a spectacle, which was how the rules of procedure were drafted. And this was absolutely unique in the history of law. Instead of having a short number of wise men just drafting 1,000 articles, or even one single person writing 300 articles in this case as a code. What we have is thousands of human beings and institutions and organizations and whoever just putting their fingers over there. And I have to say that for the history of law, this is something which will be studied for sure later on because it's unique. Yeah? At the end, we have the rules of procedure. Fine. And now, what I would like, and I will start with Klaus, what I would like to know from you is, could you write some examples of good practices that have come from the rules? And even if there is some possible criticism on something, because this is absolutely new. This for the first time ever, we have a complete code of procedure, which is absolutely European in a field, and it's the patent field.
Yeah, maybe one aim that is very important to the UPC is that it should be a court not only for the big companies with the big pockets, but it should also be a court for the SMEs, particularly the cutting that are providing cutting edge technology and want to protect it. So also for these companies, the UPC should be the right court. So for the big ones, but equally also for the small and middle-sized ones. Mm-hmm. And that means that the court should also, to some extent, be not too expensive, not too much financial means consuming, and also not too much time consuming. And one underlying idea of the rules is the way how to do it. This is to have a front-loading system. Mm-hmm. So rather than spending 2 weeks with highly paid lawyers in a courtroom in order to get to all the points that are relevant in a litigation, require them to put it down on paper and throw it to the other party and to the court. And this in a very structured manner with a strict timelines. And this is one basic principle of the UPC rules of procedure, this written procedure. Each of the parties has can go twice, so it's a ping pong, and it can be 3 workflows. It can be the ping pong in the infringement, it can be the ping pong in the counterclaim for revocation, and it can be in the ping pong if an amendment of the patent is requested by the patent owner in order to build up second defense lines. Mm-hmm. So that is a clearly defined structure, and all the parties are required to submit facts and evidence at the earliest point possible. That is very important. Mm-hmm. And that allows the court and the procedure to have everything on the table already half a year, 9 months after the start, depending on how many workflows you have. And based on this, then the second phase comes, intermediate conference, depending also on the complexity of the case, to organize everything necessary to prepare the oral hearing. At the same time, also made to find a way to settle the case. Okay, if settled, wonderful, that's the end. But if not settled, no possibilities to settle, then to go on and prepare and have it, if possible, have it all done in one oral hearing that can last normally should be no longer than 1 day, but okay, when it's very complicated, then it may be 2 days. So that is essentially the idea. And by this very organized structure, the idea is to make it possible that not too much money is spent in the proceedings before you come to a result. The result then is the decision. And very often what we can see now in the practice is that after a decision has been rendered or an order in a PI proceeding that ended one instance, the parties somehow settle the case outside. So that even can be, even if it's not the end, if not the decision, the final say, it serves as a basis for negotiations again between the party and to settle the case, because they got a kind of assessment from an independent, neutral perspective that has became aware of all the facts of the case. So that is essentially the idea, to have this all run in a very organized way. So to have a proceeding that is not only for the big pockets, but also for the smaller pockets, and to come to results as soon as possible, as soon as these normally complex cases can come to a result. Yeah.
Thanks, Klaus. Thomas, do you want to add something there? You have a...
Well, I was very happy to hear that front-loaded system is one of the best practices before the UPC, because when I was considering these practices, I noted 3 articles from the rules that are particularly important for me, and Rule 13 was one of them. So it's of course about the efficiency, transparency, and also encouragement of settlement, because a fully informed defendant may be more inclined to seek early resolution just because of this. But on the other side, there is Article Rule 9, which defines the case management, active case management, and I believe it's strictly connected with the front-loaded system. Especially with the preamble, which says that proceedings shall be conducted in a way which will normally allow the final oral hearing to take place within 1 year. And I looked up at the statistics, and this promise has been fulfilled in practice. So that's a great success for the court, that we can obtain a judgment after 1 year from the very beginning of proceedings. But there is also one additional rule which is absent in Polish procedural law, and I like it very much in other jurisdiction. Is Rule 207, which covers protective letters. And I believe from the strategical point, as a patent litigator, I see it as a very useful instrument to use before the UPC, which also enhances fairness, because it gives alleged infringers a chance to present their arguments in advance, and reduces the risk of abuse, because it prevents strategic or opportunistic ex parte injunctions, and ensures the court hears both sides of the story. So I believe that there are many good examples, and for the lawyer who is basing on comparatistic law, we can make many good comparison with other European systems.
Thank you, Thomas. Klaus, you chair the court every day, not only the court as an institution, but the court as a place where a claimant comes. And I'd like to ask you quite a difficult question, let's say, but question coming from your experience. What is your evaluation after 2 years of the attitude of the parties, the professionals, representing the parties, when interpreting the rules of procedure, which are there, but which have to be interpreted, and at the end it had to be interpreted by the Court of Appeal. What's the attitude? It's roughly speaking, yes. Do you think it's a cooperative attitude, or as a whole, or they try to find the way because there's new rules to find their way?
Okay, but you can see different approaches. One is, of course, that they look at their own rules of procedure, so where they're coming from, and then they say, okay, we do it like this in France, in Germany, and the Netherlands, and so it should be like this in the UPC. But of course, according to their interests, and then it's always so. But the direction is always clear, different from the court.
Of their clients, that's for sure. Yeah.
And yes, and of course we are that's good if we as a kind of start we become aware of what the situation is in different member states. But then of course we have to stop and think, okay, now what is in the rules, and how should we work within the rules, because it's a new set of law, and we have to interpret it. We learn from experiences in the national jurisdictions, but the rules can be different. They can be the same, they can be different. It really depends on the situation, and as the panels are always composed multinational, in particular the Court of Appeal, the 3 legally qualified judges have to come from different UPC member states. So we always get perspectives from different jurisdictions as a background. But then, of course, we always try to find to understand what is the idea of the UPC rules, because we have to think UPC. We should stop thinking national at the UPC.
Yeah. You know, Klaus, I always tell my students every day how a member of a panel of the Court of Appeal of the UPC can feel understanding that this is the first experience in the history of law, I insist, where they meet in such a multinational environment, in multicultural environment, and this is every single day. And I have the feeling that you are creating something new.
Yes, and we also have the technically qualified judges when the case comes to the Court of Appeal. We have 2 of them, and they also bring their respective background to the case, and they equally have a say in when we deal about procedural issues, like on any legal issue. Equal say, like the legally qualified just have an equal say regarding the technical issues. Of course, we respect their knowledge; they respect our knowledge. But at the end, it is a cooperation. It's a common work. Yeah.
Thank you. We always follow. It's time now for giving full priority to the questions, but I gave full priority to the questions already. So as soon as we will have new questions, I will bring them on board. I have chosen the topics to discuss. So all these topics are very dear to me, but there's this one you can understand that it's a little bit more in my heart, and it's the whole issue, which is a whole discussion, very old discussion in private international law on the so-called long-arm jurisdiction. And I have in front of me now a judgment of the European Court of Justice dated 25th of February 2025 in the BSH case, which has quite an interesting implications. Could you, Tomasz, please? I know you know the case because we have talked before about this case. Could you summarize what is at the stake and what the Court of Justice has said, and what the consequences for the UPC could be?
Well, that's a very difficult task.
Understand.
And I agree, because I remember, Manuel, one of your lecture at CEPI concerning the interactions between the Brussels regulation and the UPC agreement.
My topic, and I have discussed it with
that is your
many
topic.
times.
Yes.
Not always agreeing, by the way, which is splendid.
But let me remind everyone that even before the Unified Patent Court officially opened its doors, everyone talked about its long-arm jurisdiction. In the context, it was just about going beyond natural territorial scope of the court adjudicating patent disputes in Europe, because we are always discussing national level. However, apart from the structure of the court itself, case law also has the impact of the scope of the jurisdiction, and that is the BSH ruling. And it, I would say, it provides us with an important legal lens through which we can evaluate how far the UPC's reach may extend. So the key question was when a company sues for a patent infringement in one member state, and the defendant raises a validity defense concerning foreign patents, does this automatically shift the case to the courts of those other countries? And the CJEU said no, and this is crucial. We all remember GATT judgment from the 20 years ago. So the court confirmed that under Article 4 of the Brussels regulation, a company can always sue a defendant in a member state where the defendant is domiciled, and that holds true even if the defendant disputes the validity of the patent in other member states. Of course, as long as the validity challenge is made only as a defense, not as a standalone revocation action. So this exclusive jurisdiction under the Article 24 of Brussels regulation, which says that only courts of the country of the registration can rule of the validity, only applies to the actions aiming to revoke a patent across the board. It does not cover situations where validity is raised as a defense in broader infringement cases. So this reflects a practical and balanced approach to cross-border enforcement that favors efficiency, but also respects national sovereignty over the patent registers. So in short, I would say that this judgment helps to define the scope and limits of long-arm jurisdiction and sets a stage for a more unified and coherent approach to cross-border disputes under the UPC system, reduces litigation costs, and deters so-called jurisdiction shopping by infringers. And last but not least, for me, it places a heavy responsibility on the UPC to respect procedural safeguards and ensure genuine contendants before the claims and avoid overreach. So, in short, that is my overview.
Yeah, the case has two, let's say, two parts. This is the first part, but there is also a second part that perhaps Klaus could develop. Is the case when the validity is challenged in a third state.
Yes, maybe if you allow,
Turkey, which is the case.
It was a case that was based on a referral from a Swedish court.
Yeah.
So it essentially deals with the relation between the national courts of EU member states. However, the UPC is a court common to a number of EU member states.
Yeah.
And for these member states, currently 18 out of 27, it means that within these 18 member states, the UPC is like a national court. So it has, as a national court, has also jurisdiction on the validity of the patent. So that is, I think, out of any dispute. And then the question is, okay, how does it work when we talk about EU member states that are no UPC member states? And then the UPC is bound to the jurisdiction of the CJEU. And in that regard, I think the message from BSH already coming from Gawlicek is clear that the UPC has no jurisdiction as to the validity of the patent in a non-UPC EU member state, for example, Spain or Poland. That is clear. So then the question is, okay, how will the UPC have to deal when it is about a defendant, for example, it's a German company, and the German company is sued for infringement of a European patent that has also a Spanish part, gives protection in Spain, and also gives protection in Poland. And in this situation, I think it would be the best for the defendant, if they think the patent is not valid, to bring a revocation action in the respective, before a competent Spanish court and before the competent Polish court. But if they don't do so, while still the infringement case is pending in the UPC, okay, then the question is, how should the UPC deal with it? But probably will not be able to say anything about validity. Probably will work with the assumption of validity of that respective part of the patent, which again is enshrined in the case law of the CJEU. So that is like in the Phoenix case, where you have the presumption. mentioned. So that is one. And now the other group is, and then maybe another group which has not been mentioned, the Lugano member state, like Switzerland, like Iceland, I think, and Norway. So probably the same applies. Well, we have to see, but probably the same applies like with the EU member states that are not UPC member states. And then we have the EPO member states that are not EU member states, like the UK, like Turkey, like Switzerland. No, sorry, Switzerland is a Lugano state. So like UK and Turkey, for example. And in that regard, the approach is different because Article 24 is not applying with regard to these states, because Article 24 is only applying on EU member states, as outlined by the CJU in BSH. And then there it is possible for a court, for a national court, but also for the UPC, to my understanding, then to decide if no case has been brought in the respective national courts to explore inter partes about the validity of that part of the European patent.
Only for the case.
Only for the case, inter partes. So only between the parties. There's no effect as to third parties.
So finally, the last question could be: what if the case has already arrived to Turkey or to Serbia or
then I guess
but it's already a pending case, because then the issue is not an issue of jurisdiction anymore. Let's say it's an issue of lis pendens. How would you deal with a case like that, Klaus?
Then at least
if I may ask you.
Yeah, well, at least the court. I don't know how the UPC will decide, but what they have to do is to take this into consideration when deciding either to go on or to stay. But stay definitely is also an option in that kind of situation, and wait for the decision of the national court.
Good. No, it's very interesting because it shows also that the relationship between European Union law and the UPC applying European Union law will bring a lot of tricky questions and complex questions again on the table, and this is certainly one of them. Yeah.
And then maybe one more interesting question, but I will not give you an answer to this, I'm afraid, is how does this apply when you have a multitude of defendants and only one defendant? It's where you you only sue at the place of one of these defendants, and then the claimant says, yeah, well, they are connected, and then does the same. Does BHA also apply in this situation? The CJU explicitly only talks about Article 4. It doesn't talk about multitude of defendants. So that this is an interesting question. Okay, but we will see how this will
we will see how things come. Yeah, step by step. We have room for another issue, which I can choose from a number of issues which were very dear to me. I could choose. I have here the list. An interesting issue, Klaus. The question comes to you. You could start talking on what is your experience on the cooperation between these two different animals with different cultures, the legal and the technically qualified judges. There was an experience already in Germany, so you had some experience there, but now this is much harder. Let's say how things are working on, especially on these cultures which don't have the German understanding or the German experience. Yeah.
Yes, and I also have to say the German experience is only in one court. It's the Federal Patent Court. It is not in all other courts. It's only legally qualified judges. There's also an experience, by the way, from the Swedish courts. They also have technically qualified judges, the Austrian courts as well. So there are some courts in Europe that already have, to some extent, involvement of technically qualified judges. But of course, to that large extent, like you find in the UPC, there is no precedent for this. But I have to say the experience up to now is really positive. it helps everyone to better understand the cases when there are technically qualified judges on board. What is very important to my mind is that the view the judges are forming become transparent to the parties in the oral hearing, so that then also the technical issues can be openly discussed in the oral hearing. Because what is important to me is the right to be heard, and that should be transparent also with the technically qualified judges. Now, the technically qualified judges have different backgrounds in the UPCA. They can be national judges, like judges from Germany or from Sweden, technically qualified judges, but they can also be practitioners, so patent attorneys. And there, of course, the issue of a possible conflict of interest may come up. But we developed a system to make sure that there are no conflict of interest in the real cases. And that is done by a conflict of interest check. Every time before a technically qualified judge is allocated to a panel, and the judge is required to make this conflict of interest test check. So it is a bit like if a patent attorney, a client comes to a patent attorney and asks the patent attorney to become his representative, then the patent attorney will make a conflict of interest check and will come back to the client and say, okay, sorry, I can't take your mandate because I already work for the other side or for someone who's connected to the other side. And the same kind of conflict of interest check is also done every time before the practitioner, who is a technically qualified judge, joins the respective panel. And I think that's very important to make this clear, because there were worries at the beginning before the court started, but there are no worries any longer, no objection that respect, at least to my knowledge.
Thank you, Klaus. You want to add something, Tomasz?
I'm just looking at the statistics, because the Unified Patent Court currently employs 124, if I'm correct, legally and technically qualified judges. And among them, we have 75 technically qualified judges. So for me, the great advantage is what Judge Grabinski said, that they come from different places. So among them, we have professional litigators, judges, patent examiners. So this provides a more holistic understanding of a complex case when we have people with such a great experience. But when thinking about this cooperation, I just looked up at the UPC's annual summary, which was drafted at the beginning of this year. And there is a testimony of a technically qualified judge, Eric Ogard. And I find it very interesting, because he says that, of course, the primary responsibility for a technical judge is to understand the technical issues. But once assigned to the case, he becomes a fully fledged judge and trusted with dealing with all the aspects. So not only with technically aspects, but with legally aspects as well. And this is one of the conditions, one of the things that makes the success of the UPC, that it may not depend not just on the legal knowledge, but also on the technical knowledge. And one additional note, we just started in Poland 2 years ago a kind of discussion, of course, academic discussion on how to support the court with technical experts from the Polish Patent Office, because we do not have technically qualified judges. And I find this solution very important in patent litigation cases, where, of course, the judge must rely on expert witnesses' opinions, instead of the opinion of another judge who can support him. So I believe that the system is very balanced and is great prepared to hear the cases of this type.
Thank you, Tomasz. You want to add something, Klaus, here?
Well, maybe only briefly, because you mentioned the higher number of technically qualified judges compared to legally qualified judges. Well, the reason for this is clearly technically qualified judge must be qualified in the technology of the case. And there can be, of course, is a large variety of different technologies that can be involved, from chemistry to electronics and physics and mechanics and everything in between, pharmaceutical patents and so on. And so, of course, one or maybe even the first criteria to select a technically qualified judge to a case is the IPC class. So according to the IPC class, you know what is the technology, and then this already boils then down the number of judges that are available for a certain case. So out of, I don't know how many, it's then we have 5 different categories of judges. So you have to divide it by 5, the whole number, to find out. And then there are some technologies where we have more cases. Very busy we are in electrics, which includes telecommunication, for example, and there are other areas where we are not so busy. So that is also one aspect to be respected. And then conflict of interest I already mentioned, but of course also at least at the Court of Appeal, is preferred, as we have 2 technically qualified judges, it's preferred to have them from different countries if possible. And then another criteria is again the languages. So so if you have all these criteria, then even a high number like you have in general boils it down to only a few choices you have when you allocate a judge to a specific case.
Thank you, Klaus. You know, the global digital encounters are governed by 3 rules. Yeah. The first rule is that this is a dialogue. Yeah, we don't bring confrontations. We don't bring conflicts into the table. We bring problems into the table. Yeah, if politicians could understand one day that conflicts are not able to be solved, but problems can be solved, and we follow this first rule of the behavior of the global digital encounters, perhaps they will perform better. Yeah. The second one is that this is not at all an exhaustion understanding. We are dealing with picking up. The moderator picks several questions, but with no understanding that we're going to deal with the whole matter. Of course, we will deal many times in the global digital encounters with the UPC in the future. Yeah. And the third one is that we stick to 60 minutes. Yeah. And to your astonishment, probably 60 minutes have come to an end. Time flies. Yeah, this has been a beautiful discussion, a beautiful conversation. I would like to take just a couple of minutes, if you allow me, just to get a conclusion from you. So I give you the golden minute, let's say, first to Thomas and then to Klaus. What message could you pass if you could have only 1 minute to our audience?
Well, I would start that for me, from the outset, the UPC has been a game changer. And in essence, the UPC's first 2 years mark a period of successful establishment and promising growth. So I believe that it is clear that this is a court which is not just here to stay, but to play a pivotal role in shaping European patent litigation. And as I have only 1 minute, and as the Unified Patent Court recently celebrated its anniversary, I would like to offer my warmest wishes to Mr. President and all those who played a role in bringing this new patent system to life. May the next year be one of the great success for the court, for the judges, for the users, and for the future of Europe.
Thank you, Thomas. Klaus.
Yes, the UPC is indeed unique, at least in one respect, that is a court shared by a large number of EU member states, so common to a large number of EU member states. Currently, it is 18 out of 27, so there are 9 more to come. And Mario Draghi, the former president of the Central European Bank, clearly expressed as part of his report on the competitiveness of the EU that also the remaining 9 member states should join the Unitary Patent System, but also the UPC, the Unified Patent Court. in order to increase the competitiveness of the EU in the field of technology. And I can but support this view. I think it's very important, and it will make the UPC stronger the more member states will join in the near future. That's a very important aspect to me. And believe me, it is a true European court. All the panels are composed of judges coming from different countries. And this will be even more the case the more member states will join. And that will form a common basis so that the single European market then will also have one patent system of the same size. And in that regard, Europe, the European market, single market will then be or come also in that regard to the same levels like the other big market in this world, like we see in the US market, like we see it in the Chinese market, like we see in the Japanese or in the Korean market, just to name only a few outside of Europe. I think that is very important, and I'm very happy that I hope I could get also this message across in the context of global digital encounter.
Thank you, Klaus. Thank you. In fact, you know, the UPC arrives just at the right time. Now that the whole European construction is put into a severe crisis, let's say, it's time to say again and again that you have said, you both, that there is no way to build any internal market. There's no way to build any Europe if we don't have a unified IP system. And this is something we have to stress again and again and again. Laurent,
yes,
this was a great discussion.
Just after you, I shall mention something. Okay.
Yeah, no. I just wanted to thank all our audience, all those who will follow later on, and most especially to you both, Klaus and Thomas. It is not easy to stand for 1 hour to answering whatever question I felt like bringing to your table. You were very courageous, and I think that I have enjoyed very much this hour, and I guess that you also did it in our audience. Laurent.
Yes, thank you. Thank you very much for this very exceptional moment. Thanks to the three of you. I think that there is a lot of food for thought, food for construction of ideas, of research papers, of new passes from politics to law, let's say from diplomacy to law, from law to practice. And I think that this is an absolute superb achievement. Our group will then move to a separate room for a small debriefing between the four of us, but all my congratulations to our speakers. I would just wish to mention two things. First of all, the Global Digital Encounters adventure continues, and we will have a splendid one in September dedicated to AI at the gate, so back to the topic of artificial intelligence, before coming to other topics of international law as well in October. Secondly, this is a very special moment in the professional life of Professor Desantes, so I would also wish that we acknowledge it and thank him for being with us at this very special moment of his professional life. And thirdly, I would wish to really warmly thank our three speakers today and our participants who remained connected thoroughly to this event. So I wish all of you a nice summer period for those who can enjoy it. And we see each other in September online. And we also greet all those who will follow the session, the recorded session of this Global Digital Encounter and all the readings that will be published around. So to our distinguished speakers, please stay connected. We will be transferred to another room. And to our audience, have a nice summer time for all of you. Thank you.